Jason Shadow for a change of plea.
You are Jason Shadow?
Yes, Your Honor.
You are an American citizen?
Yes, Your Honor.
Oh, okay. Mr. O'Hearn, are you here also? You're a change of plea also, right? Yeah, okay. So you got to pay attention too. Okay, all right, got it. All right. What is the last thing I have, Mr. Shadow?
You are an American citizen.
Do you read, write, and speak the English language?
Yes, Your Honor.
Are you now under the influence of alcohol or drugs of abuse?
No, Your Honor.
At the time of this offense, were you 18 years of age or older?
Yes, Your Honor.
Since you turned 18, has a probate court ever appointed a guardian to handle your money?
No, Your Honor.
You're here today on a criminal case. In the criminal case, there are 4 pleas that you may enter. They are a plea of not guilty, that's a total denial of each and every element of the crime. A plea of not guilty by reason of insanity, which says you did the act, but you were legally insane. A plea of guilty, which is a total admission of your guilt, and there's a plea of no contest. A plea of no contest is not an admission of your guilt, but it is an admission of the truth of the facts set forth in the charging document. If the facts set forth in the charging document constitute a criminal offense, you can and will be found guilty on a plea of no contest and treated as if you pled guilty, but the fact you entered that plea cannot be used against you in a subsequent civil or criminal court case. Do you understand all that?
Yes, Your Honor.
If you enter a plea of guilty or a plea of no contest, you are giving up or waiving certain valuable and important constitutional rights, and these rights are as follows. The right to a trial by jury, to have your guilt proven by proof beyond a reasonable doubt, to subpoena witnesses on your own behalf, to cross-examine those witnesses called by the state against you, to have the services of your attorney at trial. You give up your right not to incriminate yourself, and you give up your right to a speedy trial. Do you understand giving up those rights?
Yes, Your Honor.
Do you understand if you went to trial, you would not have to testify, and the fact you did not testify cannot be used against you?
Yes, Your Honor.
All right. You are charged then one count of possession of drugs at 5, that's heroin, 1 count of possession of drugs, and count 2, cocaine, both in F5. Both of these are punishable by a 6 to 12-month prison sentence, a fine up to and not exceeding $2,500, a license suspension of not less than 6 months or more than 5 years. You understand all that?
Yes,
And give you work driving privileges during the suspension. In order to get those, you have to have proof of insurance and no other suspension in effect. You get that?
Yes, Your Honor.
Okay. If you were sent to prison for this offense, and only if you were sent to prison, when you were released from prison, instead of Iowa could but would not have to put you on post-release control for a period not less than 3 years, not more than 3 years. During that time, if you committed another offense or violated certain rules and regulations of the Adult Parole Authority, they could put you back in prison for 1/2 the time I gave you, independent of, in addition to any other penalties. And that's referred to as post-release control. Do you understand that?
Yes, Your Honor.
Anybody, other than what we put on the record this morning, anybody make any threats or promises to get you a change of plea?
No, Your Honor.
Did you tell Mr. Gackel everything there is to know about this case?
Yes, Your Honor.
And are you satisfied with his services?
Yes, Your Honor.
Do you have any questions for myself?
No, Your Honor.
Do you need to talk to Mr. Gackel outside my presence?
No.
Okay, let me take the first charge. First charge is 20th day of June 2011 in the County of Medina, State of Ohio. You did not only obtain, possess, or use heroin, a Schedule I controlled substance, in an amount equal or exceeding, you did not only obtain, possess, or use heroin, a Schedule I controlled substance in violation of Section 292511 AC 6A, the revised code, felony in the 5th degree. Do you understand the nature of the charge?
Yes, Your Honor.
Do you understand the nature of the potential penalty?
Yes, Your Honor.
When you plead this morning,
Guilty, Your Honor.
and you now withdraw your not guilty plea.
Yes, Your Honor.
And in count 2 is the same date and time, but the controlled substance is cocaine, and the violation is 292511 AC 4A, not 6A, not C 6A. So it's cocaine possession. Do you understand the nature of the charge?
Yes, Your Honor.
Do you understand the nature of the potential penalty?
Yes, Your Honor.
How you plead?
Guilty, Your Honor.
And you now withdraw your not guilty plea.
Yes, Your Honor.
Anything further from the state of Ohio on the change of plea?
No, Your Honor.
Anything further from the defense counsel?
Only that at this point in time, I believe my client is going to withdraw his motion
Oh.
for a bond review, which is
Okay.
set for this afternoon.
Right, I'm going to put on OR bond, pursuant to what we talked about earlier. All right, court finds for the record that Mr. Shad made a knowing, voluntary, intelligent change of plea. The court took the change of plea after it was satisfied by inquiry that he did understand his criminal rule 11 and constitutional rights. He did make the plea in open court and upon the record. Therefore, the court does find him guilty of 1 count of possession of drugs, heroin, Schedule 2, I believe, in violation of 29-25-11 AC 6A. This is a felony of the 5th degree, and 1 violation of possession of drugs. In violation of RC 29-25-11 AC 4A. This is also a felony of 5th degree. Got to release him on an OR bond with the requirement, with condition that he report to court and that all probation department is required. Set sentencing down for May 17th.
I believe it's the 10th.
10th, May 10th, 2012 at 8:30 a.m. Okay, so what's anticipated? So you'll get the entry on suspending execution of the sentence until May 10th, 2011, 12. You had the PSI stuff already, right?
For the previous case.
Do you need him to do another PSI with you?
There's no, we don't need one.
Okay, so do I need, okay, all right. In that case, okay, Mr. Shedd, I think I'm done with you today.
Thank you, Judge.
And I think we'll try to get you over to Summit County as fast as we can.
Thank you.
Thank you very much, Your Honor.
Sure. Can I see counsel information?